So, Dr. Limaye, first question towards you. You know, the IT Act has been here for the last 20 years or so with a plethora of rules, and especially Section 43A has been dealing with data privacy sort of issue, though in a very small way. But they were information technology, reasonable security practices and procedures, and sensitive personal data or information rules, 2011. So, when I'm saying when 43A and these IT reasonable security practices rules existed for the last 10, 11 years, what was the need of a separate data protection regulation? And you know, how do you compare this new law to the global counterparts?
Yeah. Good morning or good afternoon, everyone. And as Mr. Sumit pointed out, that Information Technology Act was in this particular domain since year 2000. And this security guidelines or reasonable security practices or Section 43A came to be enacted in the year 2008. So from 2008, reasonable security practices guidelines were already existing in Information Technology Act. But the need for this DPDP or Digital Personal Data Protection Act is now, after Justice Puttaswamy judgment, Supreme Court or our apex highest court in India has literally legalized or accepted that right to privacy is each and every citizen's fundamental right. So previously, under Section 43A, there were only responsibility cast on the service providers or where data was going to be processed on that particular data processors to process that particular data and follow reasonable security practices and guidelines. Here, after accepting this data or data privacy as each and every individual's fundamental right, the ambit of Section 43A stands more widened, and now Section 43A is applicable or literally required for each and every individual for his or her own data protection. And that's why there was a separate need or special need to make one particular enactment which will protect fundamental right of each and every citizen. So when Information Technology Act Section 43A was there, it was seen as a when personal data was breached by only the person who was processing that particular data, or reasonable security practices were not followed by that particular data processor. At that time, it would be applicable. Now, after DPDP, there are enormous changes in that particular, say, background or backdrop in which data required to be protected, and hence Section 43 of Information Technology Act is now entirely replaced by this particular DPDP Act. So your question was Section 43A was as much powerful as much DPDP is right now, but with more and widened powers. So that was the need why DPDP was specifically enacted, and now Section 43 stands repealed after enactment of DPDP.
Right. Sure. No, Dr. Limaye, I think the whole industry and the citizens have been waiting for a Indian sort of data privacy law. Of course, as one section, it only receives that much focus, but as a separate law and with the kind of penalties being proposed, I'm sure it'll receive a much better sort of focus, being the DPDP Act.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.